Good morning, everyone, and welcome to today's webinar on the Open Meetings Act. I'm Jay Hall, the Deputy Director and General Counsel for the Kansas Association of Counties. I hope that everyone is having a great day today. As Kim mentioned already, if you have questions, please type them into the Q&A box, and I'll be monitoring that so I can get your questions answered. But other than that, I think we're ready to get started. So the Kansas Open Meetings Act is about transparency, and transparency is something that obviously is very important when we're talking about government, and particularly local government, because local government is the type of government that people interact with the most. And so it is very important that we are transparent when we are doing our business at the local government level, because it's important that our constituents, that our residents understand what is going on, because local government is the level of government that most directly impacts the people that live locally. You don't necessarily interact with the federal government or the state government all of the time, but you do interact with your local government just about every day, regardless of where you live. Whether it's in subtle ways or in more obvious ways, you do interact with your local government. And so it's important that we be transparent. And part of that, obviously, is the Open Meetings Act. So I've got a question already, and it says, during an open meeting, if the meeting is to last all day, is it correct for the chairman of the board to state they're taking a recess for lunch, or is a motion to adjourn for lunch more appropriate? I guess I've always felt a motion to adjourn is to end the meeting for good after the day's business is concluded, not for a short break for lunch. So it's probably more correct to say you're going to a recess, because an adjournment would suggest that the meeting is completely over. But that's more of a technical thing. But it probably is more technically correct if you adjourn, or if you take a recess for lunch rather than adjourning for lunch. Just a little bit more technically correct, but I don't know that it's necessarily a violation if you say you're adjourning for lunch versus taking a recess for lunch. The important thing is that when you do take that recess for a lunch break or whatever, that you announce when you will be returning from lunch. So that people know when the open meeting will start again. That way, everyone knows that it's when the open meeting will resume. So that way, if other people take off and go to the local restaurant or go home for lunch or something like that, that they know when that meeting will start up again. And obviously, it's important when you announce that time, that if you say you're going to be in recess from 12 o'clock to 1 o'clock, don't restart the open meeting at 12:55. Wait until 1 o'clock to restart. So jumping back into the material, again, this is about transparency. Meetings should be open to the public because a representative government, which is what we have here in the U.S. and what we have here in Kansas, is dependent upon an informed electorate. In other words, people need to know what's going on so that they can participate in government and understand what their government is doing. All right, so today I'm going to talk to you about the Open Meetings Act, and not only what it is, but what it requires. We're going to spend some time talking about executive sessions, and then, as always, you know, I like to talk about best practices. And the reason I think best practices are so important is because when you get done with this particular presentation and you've heard everything that I've said, you need to be able to take something away from this that you can implement right now, something that you can do with the information that you've heard today, that you can go back to your county and implement. And so best practices is a great way to do that, a way for you to put into practice right away some of the things that we're going to talk about today, some of the things that we may learn today. And so that's why I like to talk about best practices. Okay, so the Open Meetings Act, what is it exactly? Well, it's what we call a sunshine law. And these types of laws exist all over the US. And it's called a sunshine law because public business should be done in the light. We don't want public business being done under the cover of darkness in back rooms, all of those kinds of things. We really want to, as much as possible, have public business done in the sunshine, in the light of day, so that people understand what's going on. Now, that does not mean, of course, that you can't have meetings in the evenings. It just simply means that meetings need to be open so that people can see what's going on within their government. And the Kansas Open Meetings Act requires that all meetings for the conduct of the affairs of and the transaction of business by agencies of the state and political and taxing subdivisions thereof shall be open to the public. What does that mean? That means that any agency of the state, whether it's no matter what level of agency that is at the state, or if it's a political or taxing subdivision, which we'll talk about here in a second, those should all be open to the public. And essentially what that means is that for cities, for counties, for townships, judicial nominating commissions, all of the various districts like cemetery districts and library districts and water districts, all of those should have their meetings open and available to the public. That's really important. And how do you know if something is a political or taxing subdivision? Well, if it's a taxing subdivision, you can follow the money. If an entity receives tax dollars, that entity is probably subject to the Kansas Open Meetings Act. So like I mentioned before, we've got all of these types of districts, whether it be library districts, cemetery districts, watershed districts, conservation districts, all of those types of districts, because they receive a tax levy, their meetings are open to the public, along with townships and cities and counties. All of our meetings are subject to the Open Meetings Act and therefore should be open to the public. That also applies for the various subdivisions within a county. So if your county has a hospital board, or if your county has a planning and zoning board, or if your county has any type of board, an economic development board that is run by the county, all of those types of things, even though they are not the county commission per se, because they are still an arm of the county, those meetings would need to be open to the public as well. And again, that's just so that people can see what's going on, so that people understand what is going on. So even if it's not the county commission specifically, if it's an entity that receives tax dollars, or if it's an offshoot of that entity, in other words, the county zoning and planning board, or the county hospital board, or the county economic development board, all of those meetings should be open to the public. So what is a meeting? I mean, we talk about the Kansas Open Meetings Act, but we have to really define what a meeting is in order to understand how the Kansas Open Meeting Act applies. And a meeting is can be either in person or through technology. We're on Zoom today, obviously. A lot of meetings take place through technology now, as opposed to taking place in person. But it can be either in person or through technology if it involves the following things. One, involves a majority of the body. Two, that majority of the body is communicating. And three, that communication is about business that could come before the body. And it's always important to note, and this is where a lot of people get tripped up, and we'll talk about this as I move through some of the material here. It's important to note that a meeting does not have to happen at the same time. Remember, meetings can happen through technology, so that meeting doesn't necessarily have to happen at the same time, because we have technology that allows us to meet at different times and in different places. So it's important to think about that when we're thinking about whether or not any sort of interactions can actually be deemed to be meetings. All right, so let's break this definition down. A majority of the body. And what's a majority? A majority of the body is half plus one. A majority is exactly what you would expect it to be. It's half of the body plus one. And I know that a lot of people tease lawyers because they say we went to law school because we weren't good at math. But the math of meetings is actually pretty simple. It's simple enough that even a lawyer can do it. You must count the total number of seats, not just the filled seats, but the total number of seats on the board in order to come to the conclusion of what half plus one is. So, for example, if you have a 3-person commission, a majority of that body is 2. If you have only 2 commissioners because you've had a commissioner resign or something like that, the majority is still 2. It's not 1 because you only have 2 seats filled at the time. It's a majority because you still have to count all of the seats, not just the ones that are currently filled. So if you have 3 seats on your county commission, a majority will always be 2, even if there has been a resignation or anything like that. For a 5-person board, that's 3. For 7, that means 4. For 10, it means 6. And obviously, if you have a planning and zoning commission that has 8 members, that would be 5 or anything like that. It's half plus 1. It's always going to be half plus 1, regardless of the size of the board. And the size of the board, you count all of the seats, whether they are open seats or filled seats. You would count all of those seats to come to the conclusion of what that half plus 1 calculation would be. You have to count all of the seats. I've seen several instances where individuals thought that they were not violating the Open Meetings Act because they only had 5 seats filled, when in actuality, it's like you still have to count all of the seats. You can't just count the ones that are filled. You have to count all of the seats. So that's something that's important to remember. And I'll probably come back to that and make that point over and over again, because that's such an important thing when you are trying to determine what the majority of the governing body is. All right, so the second part of the open meetings definition, or the definition of a meeting, after we've had a majority of the body, that majority has to be communicating. So what's communication? Communication is a back and forth dialogue. It's not just a one-way thing. So, for example, if the county commission if the county commissioners are all on an email and they receive an email from the county clerk that says the next meeting will be on January 10th at 3 p.m. That's not communicating, because they've received that, but there hasn't been any back and forth dialogue. If, however, after they receive that email, there starts being dialogue back and forth, where county commissioners are telling people that, are indicating that, well, I think we should talk about this, or I think we should talk about that, and there is dialogue back and forth between the commissioners, now you have communication. Whereas if you just receive that individual message, that's not communication. But once there is dialogue back and forth, whether that be through email or otherwise, then you have communication. And remember, communication can be through any technology. So it can be in person, certainly. I mean, obviously, we all recognize that if I'm sitting in a room talking to somebody else, that's communication. But it can also be via email, as I just demonstrated in the example. It can be over the phone, obviously. It can be via text. It can be on a video conference. It can be through any means of technology. And it's important to remember that it's any means of technology, because we don't know what technology we may have 10 years from now, 15 years from now. 20 years ago, we wouldn't have thought about video conferencing as a means for a meeting. We wouldn't have thought about things like text messaging as part of a meeting, because those were technologies that existed in their infancy 20 years ago, but weren't really widely used. But it is important to know that if those things are being used, it can be communicated. It's also important to realize that this can happen in separate phases. It doesn't have to happen all at the same time. And that's important because particularly with technology, if you send an email today and then somebody doesn't respond to it until tomorrow, and then the next response to that email isn't until next Monday, that is still communication. And that would still constitute a meeting because there is communication going back and forth between those individuals. So it's really important to remember that that extends to technology as well. On the in the same thread, if somebody receives an email and then they send a text to one of their separate commissioners, and then one of those the commissioner that received the text calls another commissioner, that's also communication. It doesn't have to be in the same medium, and it doesn't have to be all in person. It can all happen at the same time. So just keep that in mind. I've got a couple of questions that I want to address here. It says, what if there is a continuing abuse by board members only meeting in twos where one person meets with all the board members eventually? So you can meet in, board members can certainly, if you have more than 3 board members, they can discuss. The challenge when board members meet in twos is that they cannot tell the board members what they've discussed with the other board members. Because again, if board member A talks to board member B on a 5-member board, and then board member A goes and talks to board member C and says, hey, by the way, I talked to board member B and they said 1, 2, 3 about this. And then board member A goes and talks to board member D and says, by the way, I've talked to board members B and C. Now we've got an open meetings issue because those board members are aware of the communication. And so it is as if they are communicating with each other. And that's what's called a serial meeting. And I'll touch on this a little bit later, but it's where one person is effectively meeting with all of the individuals and passing along the messages back and forth. And that could be one singular board member, that could be somebody that's not even on the board. And I often warn other county employees, when you're talking to your commissioners, avoid telling them, well, I already talked to Commissioner X and Commissioner X said this, because you may be unwittingly creating a serial meeting situation by telling your commissioners, well, I already talked to Commissioner so-and-so about this. That's something that would be better saved to discuss during an open meeting rather than talking to them privately about that and disclosing that you already talked to another commissioner and that other commissioner said this thing or that thing. And that's simply to avoid the serial meeting situation where eventually all of the board members outside of the meeting have already found out what the other board members think. And again, this is because that business really should be taking place in the public. The discussions should be taking place in the public view rather than taking place because one person is going back and forth between different commissioners. That discussion really should take place in the open meeting, and that's the importance of that. So then we also had a question, what kind of official notice has to be given for a meeting and how soon before the meeting? And I will touch on notices here in just a moment. Can binding decisions on non-agenda items be made during a meeting, or do meetings have to strictly adhere to published agendas? Do all boards have to publish their meeting minutes? So we'll touch on all of these things. I'll touch on the last part first. The meeting minutes is actually more of an open records issue, and I will touch on open records next week. So if you're interested in hearing about that sort of thing, But generally speaking, meeting minutes should be published once they have been approved by the board. So until they've been approved by the board, they are considered a draft and don't need to be published. But once the board has approved those meeting minutes, which should happen promptly within the next meeting or two after that meeting has taken place. But once those board minutes have been approved, then they should be published because they would be subject to the Open Meetings Act. As for non-agenda items, so that there are a couple of different types of meetings. And we'll get into this a little bit more later when I talk about notice. But you have regularly scheduled meetings and you also have special meetings. So these special meetings, you have to strictly adhere to the agenda, the published agenda. Because it's a special meeting, and a special meeting should only be held when there are special circumstances that you need to address. For regularly scheduled meetings, you can add items to the agenda even after the agenda has been published. So you can add items to the agenda by a vote of the county commission or the body as they are taking up business. They can add items to their agenda. They can pass over items on the agenda, just like any other meeting. They can do those sorts of things during the meeting. But for a special meeting, you cannot add items to the agenda. You can only take up the business that has been set forth on the published agenda. So looking back at the technology and all of those mediums, just remember that when we are talking about having a meeting, it doesn't have to happen all at once. It can happen in separate phases, and those phases would constitute a meeting. And that's why we need to be so very careful and so very aware, because we don't want to be passing messages between commissioners or board members, and this goes for all sorts of things. So, I mean, this would constitute, even if you had, for instance, the hospital board, and one of the hospital employees talked to a majority of the hospital board about a concern. If they're telling them what other board members have said, we could be creating a serial meeting situation in that situation as well. So it's important not only that commissioners and board members understand the Open Meetings Act, but also that other employees and other public officials understand the Open Meetings Act, so that we can avoid those serial meeting situations. And finally, the last element of a meeting, of the definition of a meeting, is that the communication has to be about business that may come before the body. And this is something that is sometimes confusing for the general public, because they think that means that commissioners cannot talk to each other. And that's not the case, or that board members can't talk to each other. That's simply not the case. Commissioners, board members, they can talk to each other about things. They just need to be clear on what they can and cannot talk about. For instance, if two commissioners run into each other at the local high school football game and they talk about the game, that's perfectly fine. They can have a conversation about the game. If, however, as they're talking about the game, they start talking about maintaining the road that leads to the high school football stadium, well, now we have an issue, because now we're talking about business that could come before the body, because if that's a county road that leads to the high school football stadium, now we're talking about something that could come before the body. If we're just talking about the game and how well the team is playing, that's perfectly fine. They can have that conversation. If we're talking about popcorn and all of those kinds of things, that's perfectly fine. But once that conversation drifts to something that could come before the body, then that conversation is about business that could come before the body. So that means that if we start talking about pending agenda items, In other words, items that are on the agenda already, that we know next week we're going to have a conversation about road maintenance or about a bridge or about a specific county department. That's business that may come before the body. On the other hand, we also have to think about future potential agenda items. So when we're talking about future potential agenda items, maybe it's not on the agenda yet, but we may be, if we start talking about raises for county employees or potentially purchasing buildings or real estate on behalf of the county. That may not be on the agenda right now, but it could be on a future agenda. And so that's business that could come before the body. And then we also have to think about matters under the jurisdiction of the body. So if you're on the Planning and Zoning Commission, and there's discussion about a new business that may come into your county, well, again, that's matters under your jurisdiction. Planning and Zoning Committee members should not be discussing those types of items if they could come before that body or they are matters that are under their jurisdiction, because you may have to discuss that in an open meeting at some later point. So even if it's not on a current agenda, or if it's not something that you know is coming up, if it's under your jurisdiction, it's not something that you can discuss with a majority of the body, because that is business that may come before the body at some later time. All of the elements that we just discussed, so a majority of the body that is communicating about business that may come before the body, all three of those elements must be present in order for there to be a meeting. And what does it mean that if all three of those elements are present, that means that there is a meeting. Now, if there is a meeting, what's required? Well, KOMA requires that if there is going to be a meeting, that there is notice posted of that meeting. We had a question earlier about notice, and I want to dive into that answer now. It says, what kind of notice has to be given for a meeting? So notice is not required to be formal. It doesn't have to be on any sort of official documentation or anything like that. The notice just has to include the date, the time, and the location of the meeting. So those three pieces always have to be present in your notice. You have to have those three things. And logically, it makes sense why. In order for me to attend a meeting as a public person, as just a general person, I have to know when it is and where it is. I have to know the day it's on, what time, and where, so that I can possibly attend. And you say, well, what about for meetings that are taking place through technology? Well, again, this Zoom meeting, you all knew that it started at 10 o'clock on December the 1st. You also knew the location because you had the link. The link is the location, just like a room at the courthouse or a room at the community center or the gym at your local high school or anything like that. That's the location. The location is the phone number for a teleconference. The location is the link for the Zoom meeting. As long as you have that location, and location can be through technology, then that is part of the notice. And so you can have those meetings through technology. And if you meet those three requirements, whether your notice is formal or informal, you have communicated the appropriate notice. Now, the other element of notice is obviously that there are individuals that anybody can request that they be notified of any meeting of the county commission or the zoning and planning board or the hospital board or the township board or any of these things. They can request notice. And if they request that notice, it is valid for the remainder of the fiscal year. Since most counties operate on a December 31 fiscal year end, that would mean that if somebody requested notice today for all meetings of the county commission, you'd be required to send them notice until January the 3rd or until December 31st of this year. for any meeting that was taking place prior to December 31st of this year. They would need to renew that notice for 2023 to receive those notices, because they would not continue to receive those notices after December 31st of 2022 unless they renewed that request. They would have to renew that request at that time, even though they just requested it here today on December 31st or December 1st. That notice would only be valid until December 31st, because it's only valid through the remainder of the fiscal year. So that's the important thing to remember with notices, is that they don't have to be formal, but they do have to include all of the information that you would need in order to attend. And that those critical 3 pieces of information are the date, the time, and the location of the meeting, whether that's through technology or in person. The date, the time, and the location need to be included in the notice, but there are no formal requirements for the notice itself as far as telling people the exact, as far as specifying exactly how those notices have to go out. Now, the other important thing is that you need to make sure that your notices are being made public. Posting them on the website, if you post them on your website, you need to make sure that they are actually going out on the website and that it's not on some sort of hidden page or something like that. You need to make sure that the public actually can see your notices. You need to make sure that if you are sending out notices that have been requested, that you're not getting bounce backs on those contacts or anything like that, or that you're sending it to the correct email address if you're emailing out those notices, because again, you want to make sure that those notices are actually getting out to the public. You don't want to have notices sitting in your outbox. If you're emailing them out, you want to make sure that that email is going out. You don't want to have it just sitting still in your drafts, those types of things. You want to make sure those notices are actually being made public so that people are actually seeing them, because it doesn't do the public any good if that message is still sitting in your inbox or in your drafts folder. Now, while notices are not required to be formal in any way, I do encourage everyone to have a process for the notices. I come from a banking background, and in banking, everything has a process. And the reason everything has a process in banking is because if it has a process and you follow the process, you can avoid messing it up. I mean, it's actually really simple. If you have a process, you can avoid messing it up because you just go through the checklist every single time. So I have a process for sending out notices. It's the simplest way to avoid technical violations of the Open Meetings Act. And part of that process is making sure that whoever sets the meeting should also send out the notice. So if the county clerk is the one that sets the meetings for the county commission, they should send out the notices. And that's so that every time they set a meeting, they also know that they need to send out the notice. If the chair of the Planning and Zoning Board is the one that sets the meeting, they should also send out the notice. If the hospital administrator is the one that always sets the meeting of the hospital board, they should also send out the notices. And that is because the person that's setting the meeting knows that they have set a meeting, and so they also know that they need to send out the notice. You should have a process for how you handle special meetings, because special meetings obviously aren't going to come up all the time. You should have a process for how you send out those notices. If you know that, so if you say, for our process, we will not have a special meeting without sending out at least a 72-hour notice, then you have that built into your process. Attorney General's opinions have suggested that you need to have at least a 48-hour notice for a special meeting unless it is in the event of an emergency. And an emergency needs to be an actual emergency, not just an emergency of convenience. And when I say emergency, I mean things like, we need to have a meeting at an emergency because we need to declare a disaster because we just had a tornado sweep through town last night. And so we call a special meeting this morning at 9 o'clock. That's the type of thing that I'm talking about when I say emergency. I don't just mean, oh, this meeting time was inconvenient, so we'll just call a special meeting for tomorrow afternoon. That's not an emergency. An emergency is we need to have this meeting right now because, or as soon as possible, because there is actual danger to the public if we don't have this meeting and take action immediately or as soon as possible. And then I always encourage, if you know that you have controversial topics coming up, announce those well in advance. People pay particular attention to controversial topics. That's why they're controversial. And so if you have people paying attention, you want to put that notice out well in advance. If you know, for example, that you've got wind farms have been a controversial topic the last several years. If you know that you've got a presentation on wind farms, or that's going to be coming before your commission or your planning and zoning commission or any of those folks, put that notice out well in advance. Don't put that notice out a couple days in advance. Just go ahead and put it out early so that everybody knows that that topic is going to be covered on December the 10th. I mean, just get that out there well in advance so that everybody is aware of that meeting rather than waiting until the last minute, because as we all know, people get frustrated when they don't hear about things until the last minute. We know for ourselves, we get frustrated individually when we are not told about things until the last minute. The public feels the same way. And so if you have a controversial issue that you know is coming up, just get the notice out there early. That way people know when things are coming up and they know whether or not they want to go to that meeting, how they can go to the meeting, when it is, they can block that time off, all of those kinds of things. So just have processes in place, but particularly when you're dealing with either special meetings or controversial topics, make sure you're getting that word out there in advance. Now, I want to address this. The Kansas Open Meetings Act does not require that you allow for public comment at a meeting. That is not something that is required under the Open Meetings Act. You certainly can offer an opportunity for public comment, but that is not required under the Open Meetings Act. KOMA also does not generally require that you publish an agenda in advance. Now, as I mentioned before, special meetings are an exception for that because you do need to publish an agenda if you are having a special meeting so that people understand what is going to be covered at a special meeting. KOMA also does not require that you have meeting minutes. Now, that doesn't mean that you can stop taking meeting minutes. It's just that that's not required specifically under KOMA. What is required, though, under KORA is that you publish meeting minutes for your meetings and make those available to the public. So while it's not covered under KOMA specifically, there are requirements under the Kansas Open Records Act that deal with meeting minutes. And so I want you to keep that in mind. We have two different bodies of law that work together here. We have the Open Meetings Act that covers the meeting side of it, and the Open Records Act that covers the minutes and all of the things that flow out of that particular meeting. So now I want to talk about executive sessions. And the reason I want to spend some time talking about executive sessions is because executive sessions is probably the place where we run into the most issues when we're talking about Kansas Open Meetings Act. And that's simply because an executive session is a closed portion of an otherwise open meeting. Remember, transparency is the reason that the Open Meetings Act exists in the first place. There are reasons that you can close a portion of that open meeting. In other words, places where you can adjourn into an executive session so that the public is not a part of that particular discussion. So when you close that portion of the meeting, the public is not able to view that. And so you need to make sure that anytime you're going into executive session, that you are going into an executive session for an allowed purpose, and that you are only doing the things that are allowed in executive session during that executive session, because those are things that are not being done in the open meeting. It is a closed portion of an otherwise open meeting. All right, so the basics of executive session. An executive session is an opportunity to receive information. This is not a place for debate. It's an opportunity to get information that needs to remain private for a particular reason. It's not a place to make decisions or things like that. You are just getting information that otherwise needs to remain private. That's why you go into executive session, because you have to get information that is private. It is not, and I emphasize this, it is not an opportunity for people to say things that they don't want the public to hear. I'm going to say that again. I put it on this slide, but I'm going to say it again. Executive session is not an opportunity for people to say things they don't want the public to hear. That is not the purpose of executive session. If you're going into executive session just so you can say things that you don't want the public to hear, you are going into executive session for the wrong reasons, and you should not be doing that. Executive session is not that place. That discussion is more appropriately had in the open session. Executive session is also not a place to make decisions. You should not be voting in executive session. You should not be coming to consensuses in executive session. That is not the place. Those discussions, those votes need to take place in the open session. All right. You cannot go into an executive session if you are not first in an open meeting. Remember, executive sessions are a closed portion of an otherwise open meeting. So if you are not already in an open meeting, you cannot go into a closed portion of that meeting. You must start an open meeting before you can go into executive session. Now, you can make an executive session the first item on the agenda for an open meeting, but you cannot go into an executive session without first starting an open meeting. And that's an important thing to remember, because you cannot later on say, well, we were having an executive session and that's why a majority of the body was huddled over here discussing this or that. No, that can only happen if you are already in an open meeting. You have to go through the correct process to enter into an executive session. So what are some reasons that we can go into an executive session? And I'll cover these fairly quickly because I know that there may be questions about some of these things, but I want to at least get through these before I get into any sort of specifics. Why can't you go into executive session? Well, the first and probably the most well-utilized reason for going into executive session is to discuss non-elected personnel. Emphasis on non-elected. Elected personnel don't have the ability to go into executive session for that discussion. And this includes prospective employees. So for example, the county clerk cannot go into executive session to discuss themselves, their own salary, those types of things, their job performance with the county commission. They cannot go into executive session for that discussion because the county clerk is elected personnel. However, you can go into executive session to discuss the deputy clerk because the deputy clerk is appointed. They are not elected. So you can go into an executive session to discuss the deputy clerk because they are non-elected personnel. You can also go into executive session to discuss prospective employees. So in other words, employees that are individuals that have not yet been hired, but are applying for a different role within the county that is not elected, you can go into an executive session to discuss prospective employees. You can also go into executive session for attorney-client privilege. And I have to emphasize here as a lawyer, the things discussed need to fall within the ethical rules of attorney-client privilege. You also need to make sure that if you're going into executive session to discuss attorney-client privileged information, the attorney must be present. You cannot go into an executive session for attorney-client discussions if the attorney is not there. That makes logical sense, but I've heard of people attempting to do that, and that is not something you're allowed to do. The attorney has to be there to discuss attorney-client privileged information. You cannot go into executive session for attorney-client privilege if the attorney is not there. It is not allowed. You can also go into an executive session for employer-employee negotiations, and that's for union contracts and things like that, or individual negotiations, provided it is non-elected personnel. You can't go in there. You can't go into executive session to discuss elected personnel negotiations for salary or anything like that. It can only be for non-elected personnel. You can also go into executive session to discuss the financial affairs or trade secrets of different types of businesses. And this is something that's important, particularly in the economic development space. You can go into an executive session to discuss those types of things, but you need to make sure that it is private information of corporations or trade secrets, those kinds of things, and not to finalize the deal or vote on anything like that. It's just to gather that information. And then you can also go into an executive session to discuss things like security, a lot of things that deal with children. You can go into executive session because, again, this is privacy, medical information, building information as far as that's concerned. You can, with security and those types of things, you can go into executive session to discuss those types of things. And so it's important to make sure that you do that. I've got a question here about consent agenda, and you can certainly have a consent agenda as part of your regular meeting type of thing. Again, the consent agenda, that should be something, if you are going to have a consent agenda, that needs to be published as part of your regular agenda so that people are aware that you have items that are on the consent agenda. And you should have a process by which items can be pulled off the consent agenda by members of the body, just so that people are aware of that. But it is allowable to have a consent agenda, but you should have a process for things being pulled off the consent agenda. And an item should not be added to the consent agenda after the publication of the agenda, simply because you want to make sure that people are aware of what is on the consent agenda prior to the meeting. All right, so jumping back into executive sessions, what do you need to have in order to go into an executive session? You've got to have three things. You have to have the statutory justification for going into the executive session, the subject that will be discussed while you are in executive session, and then, of course, when the open meeting will resume. So let's cover all three of those, or let's talk about the subject and the justification specifically. And those two things need to match. So if you are going to go into executive session, for example, to have attorney-client privileged discussions, then you need to make sure that you are talking about pending litigation or something like that, because the subject and the justification need to match. If you are going into executive session under the non-elected personnel exception, then you need to make sure, again, that matches and that you go into executive session with the justification of non-elected personnel, and the subject of those discussions matches that. We've got a non-elected employee evaluations. Can they be discussed during executive session? Yes, for non-elected employees, you can discuss those evaluations during executive session. For elected employees, again, you cannot discuss those evaluations during an executive session. Only non-elected personnel evaluations can be discussed during executive session. And then I also have, it says in the minutes, do we have to have both attorney-client and pending litigation? So in your motion to go into executive session, you should have the justification and the subject. So when you have your motion, it should say under KSA and cite the statute. Under this particular clause, we are entering into executive session for the purpose of discussing attorney-client privilege and pending litigation on X matter. The open meeting will resume at 2 o'clock or however long that's going to take. But you need to have both the subject and the statutory justification in there when you're talking about that. Got another question. It says, when an agenda is set, can the board begin the next line item on the agenda early, even though it was already posted to start, let's say 11 a.m. Can they begin that item at 10:30 instead? You could do that, but it's not something that I would recommend. And that's, again, simply because if somebody says, oh, they're going to talk about the item I'm interested in at 11 o'clock, if that person shows up at 11 o'clock and finds out that you discussed that half an hour ago, they're going to be upset. So it's probably always better if you put times on your agenda that you try to stick with those times. Take a break or whatever it may be. Try to stick with those times as much as possible, because again, if I'm interested in one particular item as a member of the public, and I show up at 11 o'clock expecting to hear the discussion of that item, and I find out that that item was discussed and they voted on it 20 minutes ago, I'm going to be upset as a member of the public, and understandably so. And so it's really important, if you are publishing times on your agendas, that as much as possible, you try to stick to those times so that people know when those items that they're interested in are coming up. All right, so let's talk about some best practices. I know I've got just a few minutes left with you here this morning. So I want to talk about best practices, because these are the things that you can really take with you and implement just in your normal daily practice of what you're doing right now. And the first one is to always remember to plan ahead. It's important that you're planning ahead when you are dealing with open meetings. And that's planning ahead as far as notices and having your processes. That's planning ahead if you're having a special meeting to make sure you have a process to quickly get those notices out, particularly with special meetings, because those often are created after an emergency or disaster. Make sure that you have a way to get that notice out, even if you can't necessarily get to your office computer or your office to send those out as you would normally. Have some sort of backup plan. Make sure you're planning ahead for that, because when an emergency comes up, you're not necessarily going to have a way to just all of a sudden create that process on the fly. And again, with notices, have a process. I really encourage having a process when you're dealing with notices. Make sure you follow your process once you have a process. There's nothing more frustrating than seeing that somebody has a great process in place, but they don't use it. They don't follow it. Processes are worthless if you don't follow them. Always make sure you're having that process and that you're following that process, and finally, that you're being consistent. If you are consistently following your processes, that's going to make your life so much easier, so much better, particularly when you deal with notices for open meetings, because when you are getting those notices out, it will run and function like clockwork. It will make everything you do that much easier if you're doing things that way. Write out your executive session motion in advance. If you know an executive session is coming up, one of the great ways to make sure that your subject and your justification are matching is to get that typed up in advance, and you can just fill in the blanks once you get to that, as far as what time you're gonna come back into the meeting. You can do that in the meeting, but otherwise have that subject and that justification already written out so that you know that you are covering all of the necessary elements when it comes to going into executive session. Along those same lines, keep the discussions that you have in executive session confidential. And this is something that's really important. You're going into executive session because the things that you're discussing in that executive session are things that require privacy. And so if you're going into executive session because those things require privacy, those discussions need to be kept confidential. You need to make sure that you are not disclosing the discussions that are happening in an executive session outside that executive session, because those discussions need to be confidential. And I say this because as a lawyer, one of the things that can break attorney-client confidence is if the client discloses that information to another individual, and you could lose attorney-client protections by disclosing that information to other individuals. You should be treating all of your discussions in executive session with that same sort of confidence, with that same sort of privacy. If you are discussing something in executive session, it needs to be discussed in executive session. And then after executive session ends, that discussion needs to be tabled. You cannot be disclosing that to other individuals. Along those same lines, if you are within executive session, if you receive some sort of handout or if you take notes during executive session, that handout, those notes need to be disposed of prior to going back into the executive session, whether that's your county counselor collects those notes, or you give those evaluations back to the county clerk to be placed back into the employee's file, or to your HR officer, or whatever it may be. All of those things need to be done, because if you just leave that paperwork laying on your commission table or on the planning and zoning table, when everybody comes back in the room, that now can become an open record, because the press or individual members of the public may see that, may pick it up, and now again, you've lost the confidentiality of that. So keep those discussions confidential. Make an effort to make sure that you are keeping those discussions confidential as you are returning from executive session. And then finally, don't return from executive sessions early. Just like you would not return from your lunch break early and start. If you said you're coming back at 1 o'clock, don't start at 12:59. Don't start at 12:55. You can start at 1:01 if you'd like, but don't start early. Please do not start early. Again, people will be frustrated if they come back in and find out that the item that they were waiting till after lunch for you to discuss, that they walk in at 1 o'clock and you discussed it at 12:55 because you got started a little early. That covers all of the information that I had for you today. If there are any questions, please feel free to type them into the chat or type them into the Q&A. I'd be happy to answer those questions. As Kim mentioned in the chat, we do have a session on open records scheduled for next week that we are looking forward to as well. But if you have any other questions about open meetings or open record or open meetings, please type those in right now. I see I've got a couple that are coming in right now. Let's see if we have anything. We've got a question. If the board members do share with D what A, B, and C said, what is the recourse of a citizen? The one thing that I didn't get a chance to cover today, because I knew I would have, we'd be pretty close to the end, is that if you do have, if there are violations of the Open Meetings Act, those violations can be investigated by reporting those to the Attorney General's office. And obviously I put on programs like this so that we can avoid those types of things, because all of our county individuals know exactly what is and is not allowed in the Open Meetings Act. And so, but if they do keep doing that, the recourse is obviously being reported for an open records or an open meetings violation. But again, that's something that we want to try and avoid by obviously following the law and making sure that we are not doing things that would violate the Open Meetings Act. Any other questions? I don't see any other questions, and I don't want to hold everybody else too terribly long. If you do have questions, feel free. My email contact information is on the slide. I think most everybody has my my contact information. So if you do have other questions and you want to get in contact with me, feel free to give me a call or drop me an email. I'm always happy to answer questions. But other than that, thank you for attending today, and I hope to see a lot of you on next week when we talk about open records, kind of the other side of sunshine laws, the Open Records Act. But other than that, thank you for attending this morning and have a great day.